coming on Thursday afternoon. You know, it's your favorite thing to do. Appreciate you being here. I'd like to introduce, I'm Professor Strasser, if you haven't met me. I think I've met most of you. This is Professor Michael Skerker. Dr. Skerker is a professor in the Leadership Ethics and Law Department at the United States Naval Academy. Professor Skerker taught at the University of Chicago, that's where his PhD is from, as well as DePaul University before joining the USNA faculty. His academic interests include professional ethics, just war theory, moral pluralism, theological ethics, and religion and politics. His publications include works on ethics and asymmetrical war, moral pluralism, intelligence ethics, and he has this book out, The Ethics of Interrogation, from University of Chicago Press. I highly recommend it. He's currently working on a book about the moral status of combatants. He also presently serves on the advisory committee for the High Value Detainee Interrogation Group Research Unit. This group, this interagency group, is reforming our interrogation training for all federal agencies. Today, Professor Skerker is going to talk to you about the rights of irregular combatants. Thank you again for coming, and please join me in welcoming Mike.
Thank you, Brad. Thank you very much for having me here. I'm deeply humbled to be here. I had the opportunity to teach 2 classes yesterday, and I'm just terribly impressed by you all, terribly impressed by this institution, so it's a real privilege for me to be here. Recent events in Boston gave me a new introduction to this talk. The debate over what to do with Johar Tsarnaev reminded me of a conversation that, having been interrupted, simply picked up where it had left off. Let's look at what a few people have said about it.
I'm a little bit concerned because now he's, you know, he's got his Miranda rights, the right to remain silent.
Miranda is the guy or not?
I don't understand the point. First thing with the telling is you have the right to remain silent. Fantastic. So the bombs that could be exploding and the pots that could be unfolding, we can't ask him. Okay, first of all, due process.
So Jim's sending amendments. So Tim McVeigh, Ted Kaczynski, Ramsey goes to, so there goes, so that whatever the suspect has done or did, guaranteed right to due process.
I think it's a mistake not to treat him as an enemy combatant.
We ought to look at him as an enemy combatant and moving him toward a military tribunal.
Yes, the civilian trial, dead or in prison, huh? Well, freedom and way of life, right to a fair trial and speed. What's next?
This guy ought to be, right now, being interrogated in a very intense way. I'm waterboarder. I don't believe enhanced interrogation is torture. I don't.
You don't.
These comments should remind you of debates you've already heard. The debate over what to do surrounding the so-called underwear bomber, Abdul Muttalib. The debate over whether or not to bring Khalid Sheikh Mohammed. The debate to whether to bring Khalid Sheikh Mohammed to Manhattan for federal trial. The debate in 2009 in congressional hearings over whether or not a captured bin Laden should be Mirandized. The debate in 2001 about whether to give captured Al-Qaeda and Taliban operators POW privileges in Afghanistan. There are genuine moral and legal puzzles here about how to treat militants who aren't quite soldiers and aren't quite criminals. In 1991, it was clear what to do with captured Republican Guard soldiers. But look at some of the militants with whom U.S. forces and their allies have clashed over the last 12 years. Look at their appearances, and I know some of you have seen these guys up close. Think about their tactics as well. We have the Taliban, the Pakistani Taliban, Saddam Fedayeen, Ba'athist guerrillas in Iraq, Al-Qaeda. Al-Qaeda in the Arabian Peninsula, the Mahdi army in Iraq, Al-Qaeda in the Islamic Maghreb, the guys who've recently taken over Mali, Al-Shabaab, opium traffickers in Afghanistan, militias loyal to warlords in Afghanistan, and Somali pirates. Today, I want to talk to you about the rights of irregular fighters like these gentlemen. Clarifying the rights of different sorts of irregular fighters, in turn, will clarify how U.S. forces and their allies must treat them in detention, interrogation, and trial. To be clear, unless otherwise noted, the normative language I use will be moral language rather than legal language. My positions are articulated at greater length in my book that Professor Strasser mentioned. If you want me to expand on any of the things I touch on quickly here, we can address that in the Q&A sessions. I have 4 parts to my talk today. After clarifying some misconceptions about due process that those Fox pundits evinced, I'm going to talk about the rights of domestic criminal suspects, and then the rights of POWs, and then fourth, talk about which of these 2 sets of rights are appropriate for unprivileged irregulars, folks like Al-Qaeda operators. Or if a third mode of interrogation, detention, and trial is appropriate for irregulars like those guys. Part 1, preliminaries. It's claimed by some that terrorists don't deserve due process protections. This argument confuses punishment with the legal procedures aimed at determining criminal culpability. The latter is meant to assess the level of guilt prior to levying punishment. If punishment is appropriate, it's to be handled by different actors in different institutions than those interrogating and trying a suspect. In short, there's a difference between an interrogator and a jailer. Further, as a matter of fact, the U.S. routinely affords due process protections to people suspected of the most heinous crimes, whether they're U.S. citizens or foreigners. Whether they're captured domestically or whether they're captured abroad. The type of alleged crime does not offer salient distinctions either. Crimes addressed in the U.S. courts include crimes directed at private citizens, crimes seeking to corrupt the functioning of government, and cases of domestic terrorism meant to overthrow the government. While the 9/11 attacks have been termed acts of war by some people, this phrase doesn't actually have a legal definition. Nations have judged violations less severe than the 9/11 attacks as causes for war. And some nations have suffered greater harms without going to guns. Now it's true, bin Laden and al-Zawahiri declared war on the U.S. in a 1998 fatwa. But so what? Just because 2 guys declare war doesn't mean there's a war going on. Due process is for the benefit of the innocent as well as those suspected of crimes. Perhaps it's tempting to insist that terrorists are somehow different than murderers or rapists and don't deserve due process protections. We saw how the possibility of Johar Tsarnaev being given a Miranda warning seemed to bring pain to those Fox News pundits. On this point, it strikes me as curious how differently some people spoke, for example, of the Aurora theater shooter, James Holmes, and the alleged Boston bombers. In Aurora, Colorado, U.S. citizen James Holmes shot 70 people with guns, killing 12 of them. He left his apartment booby-trapped with bombs. U.S. citizen Johar Tsarnaev allegedly helped kill 4 people, 3 with bombs, 1 with a gun. There were calls to treat Tsarnaev as an enemy combatant immediately after his identification, prior to any information about his motivations or affiliations. Whereas, as far as I remember, there were no such calls for James Holmes. I take it that some people assumed, since Tsarnaev is Muslim and of an ethnicity associated with the rested part of the world, they assumed he must have been acting for political purposes, rather than simply because of mental illness or for financial reasons, like the DC sniper. Well, the entire point of due process is to avoid assumptions like those and to find the actual truth of the matter. I would like to think that on reflections, those pundits we listened to a few minutes ago do not really want a government that renders people guilty by fiat, by just snapping its fingers, or which determines the crime with which a person will be charged based on their ethnicity or religion. Again, there's a difference between the method for determining criminal culpability and punishment. Due process protects people not charged with crimes as well as criminal suspects. It's important to remember that. States are forced to develop competent investigation and prosecution services when they're asked to, quote, shoulder the entire load of proving a person's guilt. So provisions, states are more likely to find and convict guilty parties. For example, you show me a developing country whose police department's method of crime solving is to beat false confessions out of people, and I'll show you a police department that's incompetent at solving actual crimes. Citizens should demand that states hew to due process protections and procedures, even when people are caught red-handed, like James Holmes or Jilkard Sinai. Because citizens should want the investigative services of its government to be in good shape when there's a really tough case, when people aren't caught red-handed. Citizens should also want criminal justice systems that respect the rights of the accused, even in cases when the person is obviously guilty, even if he admits it right off the bat to investigators. Falsely accused people can utilize these same rights and privileges to prove their innocence. In short, you can't deny rights to someone you believe is guilty and then demand those rights for yourself if they suspect you of being guilty. All right, so that's part one. Now part two. There are two key questions in determining the state's treatment of a given class of persons. First, what moral or civil rights does this class of persons enjoy? Rights form an initial boundary on a state's behavior, a kind of bubble around people that states shouldn't violate. Second question, what are the state's aims in the particular arena in which this class of persons is encountered? I want to talk now about two rights related to interrogation. First, people have a right to mental privacy, to have a kind of mental space free from others' interference where they can formulate ideas and protect sensitive information. The right to silence is an expression of the right to privacy when one is being questioned. If I have a right to privacy and silence, then I don't have to share with you what's on my mind. I don't have to tell you what my wife said to me last night. I don't have to tell you about my religious beliefs. That's private. States properly defer to criminal suspects' right to silence in recognition of the possibility that they're innocent. If a suspect really is guilty, he doesn't have a moral right to keep criminal secrets. Where I hid the heroin is not a morally privileged secret like a religious opinion or a lover's confidence. The criminal has abused his rights to privacy and silence by using that privileged space that others properly respect in order to plot crimes against their interests. Were he to present flagrant evidence of wrongdoing, let's say bragging to somebody about stolen loot, others could demand to know his criminal secrets. But here's the thing. In most cases, investigators do not know he's forfeited his moral rights to privacy and silence by plotting. Investigators' possible subjective certainty that the guy is guilty does not overcome their objective fallibility. So, for example, these two innocent men were pictured on the cover of New York Post as suspects in the Boston bombing simply because they were wearing backpacks. They were in the wrong place at the wrong time with the wrong accessories. That's how suspicion works. So the fallibility of state agents, coupled with the baseline respect for an inhabitant's freedom that liberal states properly observe, entails that such states cannot suspend the recognition of suspects' rights by fiat, just by snapping their fingers. Instead, they must treat them as much like an innocent person as possible until they reach the political equivalent of certainty of the person's guilt. And they only do that with a criminal conviction. Deferring to a right to silence is a key way of maintaining a balance of investigating somebody, which necessarily entails infringing on their rights, while respecting the fact that they're still maybe innocent. Police can still defer to a suspect's privacy and autonomy, even while physically detaining him, even while bothering him with personal questions, if they suspect a suspect's refusal to cooperate without threatening him or levying punishments. An admonition about the right to silence, such as given in the Miranda warning or the Article 31 Bravo warning in U.S. military law, is a way, I think, of the government telling a suspect that contrary to appearances, the government still considers the suspect possibly innocent, acknowledges the state could be mistaken in its assumptions, and allows the suspect is free to act like an innocent person in the sense of ignoring strangers' intrusive personal questions. So again, Miranda warning is a way that the police officer is saying, look, I know I'm treating you in part like a guilty person. I am detaining you, I am asking you personal questions. But I also appreciate you could still be innocent. So you, like an innocent person, can ignore me, can refuse to answer my questions. Again, despite an individual investigator or TV pundit's subjective certainty of a suspect's guilt, the state does not really know he is guilty, does not really know he's abused his rights to privacy and silence by criminally plotting. Judges and juries can also be more confident that a confession was authentic if they believe the Mirandized suspect didn't feel coerced into confessing because he was threatened with a beating or threatened with jail time. Now, it should be noted that contrary to what some of the pundits said, the Miranda warning does not mean detectives may not interrogate the suspect. You give the Miranda warning, a suspect can waive it, and then you can go ahead and ask him questions. It should also be noted that the Miranda warning has had little effect on confession rates in the U.S. A 1994 study of 3 American urban police departments showed that 78% of those Mirandized waived their rights and talked to detectives. Of those people who were guilty, over 2/3 confessed within an hour, and that's all with non-coercive interrogation techniques. Part 3. Now I'll talk about POWs. According to post-Westphalian just war theory, the last 400 years, service personnel in war are permitted the unusual privilege of killing one another and destroying military material in equal measure with their enemies. This because they're carrying out the orders of a state rather than acting from immoral personal motives like a criminal. Conventional combatants in an interstate war had a right to their tactical secrets, I would assert, because and when they regard morally upright activities. They no more wrong enemy interrogators by silence or lies than they wrong the enemy by attacking him prior to capture. So I want to stress that. The idea is if you're allowed to serve in the military, if you're allowed to engage in tactical maneuvers against the enemy, the secrets regarding those maneuvers, you have a right to them. You're not wronging the enemy by concealing those secrets. Now, just the same, since their enemies are permitted to counter their battlefield maneuvers with measures like camouflage and trickery, military interrogators can adopt deceptive or emotionally manipulative tactics to counter their detainees' silence or evasions. Since the shackled POW is not a physical threat to anyone, physical violence against him is disproportionate and impermissible. This is the basic argument against torture. He's not a physical threat to you, so you can't hurt him. Since he has a right to his tactical secrets, he may not be threatened with impermissible violence or threatened with the revocation of POW privileges, which I outlined in number 1 of your handouts. Nothing about his detention may be punitive. The POW has no need of a lawyer since he's immune from prosecution for ordinary combat activities. Irregular combatants who act act at the behest of a state or a remnant state or an emergent state may have moral claim to belligerent privileges and POW status and detention instead of criminal prosecution. This, first, when they are the armed wing of a political entity directing violence against their enemy's military apparatus for a just purpose. And just purposes include these sorts of things. Second, they maybe do POW status if they fight in a just manner, if they treat inhabitants of territory they control in a decent, rights-respecting manner. Now, if one feels some discomfort extending POW privileges to irregular groups, be it the Viet Cong, the Taliban, Ba'athist insurgents, maybe Hezbollah, remember that receiving POW designation doesn't mean that one fights for a noble cause. Allied forces gave soldiers fighting for the Nazi regime POW status. The basic test for POW status is whether the militants' violent actions are for personal gain, like kidnappers or drug dealers, or if they're fighting for a political purpose, like conventional combatants. The basic argument is that if you look at and are motivated like a conventional combatant, you should probably be treated like one after you are captured. Absent these qualifiers, absent these justifications for POW privileges, militants lose the corporate privileges of those wielding political violence and can be punished on an individual level as ordinary criminals. Now, a few notes about terminology before we proceed. The words terrorist and guerrilla describe tactics that can be used both by states and by non-state actors. So for my book, I developed a typology of irregular militants based on their relationship with a settled political entity and their motivations, rather than their tactics. I have that on your sheets in section 3. Now, Al-Qaeda Central members are what I call unprivileged irregulars. They are not privileged irregular combatants because they do not have concrete ties to a particular people, they do not control territory, and they certainly do not obey the rules and customs of war. So, unprivileged irregulars like Al-Qaeda operators do not have a right to their tactical secrets, since these secrets concern what are effectively criminal actions. Now, that's fine, but here's the difficulty for counter-terrorist forces fighting Al-Qaeda. A non-uniformed, unprivileged irregular looks to be detaining power just like an innocent civilian. He's just a guy in a turban. An Afghan, Iraqi, or Yemeni captured in the vicinity of a weapon, holding a weapon, even using a weapon, isn't necessarily an irregular fighter any more than, say, a Texan using a weapon is an irregular fighter. Well, what if he's caught red-handed attacking government forces? Obviously, you've got more evidence there that he's an irregular fighter. But then again, how many Texans wouldn't shoot masked intruders in their property late at night? So I argue that far from being freed of the necessity of acting in a morally scrupulous way overseas, counter-terrorist forces should be even more careful in obeying at least the spirit of due process when detaining foreign nationals abroad. State agents, like police, can justify their rights-infringing behavior toward domestic criminal suspects with the rationale that a relatively crime-free environment is in every inhabitant's interest. But say a CIA team isn't acting to suppress local crime in Italy when seizing a suspected Al-Qaeda recruiter off the streets of Milan. State agents may take proportionate steps to defend their states, and these steps might include kidnapping irregular suspects in countries with unreliable law enforcement partners. But a wrongly suspected person is purely wrong if they're detained by foreign agents, even if those agents don't act wrongly in detaining them. The target does not have any kind of social contract with those foreign agents justifying their rights-infringing behavior. So I want to be clear about this. This is important. If an American police officer arrests me with reasonable suspicions that I'm a bad guy, my rights are infringed upon. He's controlling me, but they're not violated. Because the overall enterprise of arresting suspicious people benefits me and my family by creating a relatively crime-free environment in the US. But if Canadian police arrest me, that's not helping me in America enjoy a crime-free society. Now, these natural rights violations are compounded if a suspect is tortured, held without charge, or denied the means of challenging his detention by foreign agents. Having discussed modes of state behavior proper to two types of individuals, POWs and domestic criminal suspects, one wonders if unprivileged irregulars are so different from ordinary criminals and privileged belligerents that a unique approach in interrogation, detention, and trial is warranted for them. Now, unprivileged irregulars like this are usually acting for political ends, like privileged belligerents. But they lack rights to commit acts of violence and to keep operational secrets, like ordinary criminals. Like ordinary criminals, they do not usually self-identify, and so state agents need to develop tools to identify them without treating all suspects as if they're actually guilty people. Now, the question to bear in mind as we proceed, in addition to the rights and liabilities of irregulars, is this. Is there anything the detaining power would want to do with suspected unprivileged irregulars that it cannot do with law enforcement or POW-style approaches? There's no need to reinvent the wheels. Now, since torture is an unreliable interrogation tool, as well as a moral catastrophe and a cancer in any government, we can exclude it from our wish list. And we can talk more about that in the Q&A period if you want. By contrast, non-coercive interrogation techniques of the sort used by police and the FBI are generally effective. The non-coercive interrogation tactics used by law enforcement and military interrogators are nearly the same. The only possibly efficacious tactics excluded from either law enforcement or POW-style approaches are threats and blackmail. And both should probably be excluded for practical reasons. Now, having excluded a third type of interrogation, detention, and trial for unprivileged irregulars, the criterion appropriate for the detaining power to use in deciding whether law enforcement or POW-style interrogations is apt is whether its paramount concern is gathering intelligence or gathering indictable evidence. You have this map in the back of your handout, the last one. This is part of it. Now, in the former case, when we are looking to gather intelligence, POW-style interrogation offers more flexibility in that there's no time limit on interrogations and no lawyer to perhaps precipitously end interrogation. This concern about interrogations ending too soon was, I think, at the heart of Senator Lindsey Graham's argument for designating Tsarnaev as an enemy combatant. Again, I have to ask him, though, what initial evidence was there that Tsarnaev was a member of an organized armed group and not just another mentally ill person with easy access to weapons? POW-style interrogation's departure from due process does create a more coercive environment where subsequent confessions can be judged less reliable. Civilian criminal trials can proceed if the government is confident that it has indictable evidence not relying on the detainee's interrogation. and the disclosure of which would not compromise classified sources and methods. Battlefield or extraterritorial seizures of irregulars will not necessarily prejudice prosecution in the U.S. because of the so-called Kerr-Frisbee rule, which allows, this was news to me, for entry into trial even following non-traditional methods of interdiction. Operations in foreign theaters like Afghanistan or Iraq with, well, how should we put it, less refined legal cultures, routinely see low-level, unprivileged irregulars turned over to indigenous law enforcement after U.S. interrogators have finished with them. With a civilian trial, let's say of a suspected al-Qaeda figure, the government can secure one of its two presumed goals: long to lifetime incarceration or the execution of the irregular. Going the civilian route has many advantages. The government, its citizens, and the wider world can all also enjoy more confidence that guilty parties have been punished. Unprivileged irregulars are denied whatever prestige and dignity comes from a lawful belligerent association, a lawful belligerent designation. Hewing to our own values, even with those who reject them, in a manner akin to giving medical treatment to enemy combatants, testifies to the strength of these values. It testifies to the fact that we won't have our behavior dictated to us by monsters. The government should not use the less reliable confessions produced in a POW-style interrogation in a civilian trial if the government lacks other indictable evidence. This leaves the options of holding a military commission with weaker due process protections, permitting the use of confessions procured by military or intelligence interrogators, provided, quote, that the totality of the circumstances renders a statement reliable and voluntary, end quote. A full array of punishments are possible, though convictions, and particularly executions, will likely be seen as less legitimate given the unorthodox nature of these trials. Advocates of this route for suspected al-Qaeda operators seem to assume that a military system is somehow harsher or has a higher rate of conviction. Actually, post-2009, detainees in military commissions have nearly the same rights as domestic criminal suspects. JAGs, who would be prosecuting them in military commissions, are fully accredited lawyers, certified by the ABA. They're not half lawyers. And the conviction rate of al-Qaeda and other militants in federal courts is excellent. Another option, and I admit a more radical option, is to designate interrogated, unprivileged irregulars, like al-Qaeda suspects, as POWs, and hold them, as Geneva Convention permits, until the end of hostilities, which in the case of militant Salafist Islam might well be a generation or more. Now, to be clear, POW designation would be in spite of these irregulars' failure to qualify for POW status. While I admit this is somewhat disconcerting, it's not unprecedented, as U.S. forces afforded Viet Cong prisoners POW status despite their failure to qualify for that status. According to President Obama's March 7, 2011 executive order, 48 Guantanamo detainees, whose treatment and interrogation makes both civilian trials and military commissions impossible, will be held indefinitely without trial under the color of military law. This fairly stunning and little noticed maneuver from a so-called liberal president would seem to amount to POW designation in everything but name, and perhaps is done in this ad hoc and legally novel way to avoid the rhetorical legitimization of al-Qaeda members as privileged belligerents. The downside of this approach, just summarily designating people and holding them for the rest of their lives, is that the detainee review boards, which review the detainee's status, do not have the robust adversarial mechanisms of civilian trials or military commissions. The benefits of formally designating detainees as POWs would be to hew to an established legal framework of international legitimacy. This POW route, in the absence of any kind of trial, would preclude capital sentencing. You wouldn't be able to execute. The POW route would permit detainees the privilege of writing their families and living in secure barrack-style housing instead of supermax-style solitary confinement, both of which seem to be reasonable humanitarian privileges. There's less of an impetus for a POW-style interrogation if a suspected, or positively identified Al-Qaeda member is not presumed to have sensitive intelligence. If indictable evidence already exists against the suspect, then a law enforcement-style interrogation offers the prospect of more reliable information, more international legitimacy, and a more secure route to a civilian trial. This would include, for example, this would have included Osama bin Laden, who was convicted in absentia in 1998. If a confession is needed for indictment of other charges, then the due process protections associated with a law enforcement style interrogation are necessary to secure usable evidence for a criminal trial. So, in summary now, what to do about Qaeda Tsarnaev? Legally speaking, he could not have been designated an enemy combatant because he's a U.S. citizen. But let's say for a second that he was not a U.S. citizen. It would be hard to determine whether it was more pressing to seek indictable evidence or intelligence from him at the point of arrest, because at that time it was unknown